Hello, I'm Professor Frank Askin of the Rutgers Constitutional Litigation Clinic, and you're watching North Shore Magazine.
Hello, and welcome to North Shore Magazine. I'm your host, Fred Hadley, and today we have a very, very special guest, and that would be Professor Frank Askin of the Constitutional Litigation Clinic at Rutgers University. How do you do, Professor?
Good afternoon.
How are you, sir?
Okay, just fine.
Okay. Now, you've been in the news a lot lately, and it has to do with a development in New Jersey, on the New Jersey Turnpike, Exit 8, I believe, called Twin Rivers.
Right.
Can you give us a little background on what's going on there?
Well, Twin Rivers is the oldest planned unit development in New Jersey. It's a community of some 3,000 dwelling units with some 10,000 residents. It's actually the population of Twin Rivers is actually larger than the population of 2/3 of the municipalities in New Jersey. It's a community that it's not a gated community. In fact, there's a public highway that runs right through it, and a little strip mall there along the public highway. And it includes townhouses, standalone houses, some condominiums within it, and 3 apartment houses. And it's governed by a board of directors, like most of these common interest communities. And several years ago, some of the residents came to us. They thought that there was a bit of totalitarianism going on there. It just wasn't democratically run. They wanted more right to democratic participation. And as a matter of fact, we had met with a number of residents from different common interest communities in New Jersey, all of whom had complaints against their boards. And we picked Twin Rivers as our test case. You have to understand that my clinic has been spent the last 20 years expanding rights of freedom of speech under the New Jersey Constitution. I'm really talking about speech in what many people consider private property. We started with shopping mall litigation in New Jersey. We finally established in 1995 that New Jersey's suburban shopping malls were public forums where people in nonprofit groups, politicians had a right to go to collect petitions, give out literature. You have to understand that under the U.S. Constitution, the First Amendment, these places are considered private property. So the owners of the property can do what they want and exclude whomever they want. But in New Jersey, we established the proposition that under the New Jersey Constitution, these shopping malls were public forums. We then began to extend that concept of what I call free speech in private space into residential communities. And as a matter of fact, even before our shopping mall decision came down in 1995 from the state Supreme Court, I had brought an original suit against the Galaxy Towers in Guttenberg, New Jersey. Now, that was a case that we brought on behalf of some outsiders to Galaxy Towers. It was another local political group. The Galaxy Towers is in Guttenberg, New Jersey, a small community, 6,000 residents all told, 2,000 of which lived in Galaxy Towers. And the Galaxy Towers had a very active political action committee. They lobbied their residents constantly, slipped material under the doors, and they basically dominated local Guttenberg elections for school board or town council. While Galaxy Towers was only home to about a third of the Guttenberg population, they were such a solid political bloc that they totally dominated local politics. And the outside group, the Guttenberg Taxpayers and Rent Payers Association, they wanted to be able to come in and campaign in the building the same way the Condominium Association did. And of course, they were told, no, you can't come in here, we're private property. So I agreed to represent this outside group, and we filed a suit to get them access to the Galaxy to campaign in the same way that the Condo Association did. And the first thing that happened was that the Chancery Judge in Hudson County, New Jersey, threw us out of court. But the time we got to the appellate division in New Jersey, the state Supreme Court had decided our shopping mall case, saying that, well, certain private entities have to recognize rights of expression and association under the state constitution. And as a consequence, the appellate division remanded our case to the trial court in Hudson County, and the trial judge had a full-scale hearing, and we won. And it was about 1996 by now, maybe 97. We got a ruling from the Hudson County Chancery Division that our clients, the Guttenberg Taxpayers Association, they had the right to campaign in the building in the same manner and to the same extent that the Condo Association did. In other words, if they wanted to make it a politics-free zone, they could do so. But as long as they were campaigning, the court said it could not be a political isolation booth, and both sides had to be heard. And that was then affirmed by the appellate division in New Jersey. They tried to appeal to the New Jersey Supreme Court, and the court would not accept their case. After that, we started getting, now remember, that's third party. That's outsiders who want to come into the community. And what they won was a right of reply. They didn't win an absolute right to come in. They had a right to come in to campaign the same way the association did. We then started getting inquiries from members of these common interest communities in New Jersey, members themselves. They wanted rights. Well, if outsiders have some rights in these communities, why shouldn't we have some rights? And we met, as I say, with representatives of 6 or 7 of these communities where they had sort of nascent little homeowners groups who didn't like the way their associations were being run. And by the way, I live in a gated community. It's run very well. I have no problems with it. And a lot of these communities run fine. Unfortunately, some of them, people get their hands on a little power, and as it said, power corrupts. And these people tend to become sometimes petty despots. And they cause a lot of problems. So we met with these people, and they have a statewide sort of coalition, a very small group, not much funding, called the Common Interest Homeowners Association. And we decided we would take on Twin Rivers as our test case for what I call the right of democratic participation. And we filed the law. We first tried to negotiate with Twin Rivers and their attorneys, couldn't get anywhere. And finally, in around December of 2000, we filed a lawsuit against the Twin Rivers Homeowners Association. And we raised, I think 9 points in our complaint, with 9 rules that we thought were too restrictive.
Just to clarify for our viewers, sure. The Homeowners Association would be the equivalent of the Board of Directors?
That's correct.
Right, because in the complex that I live in, North Shore Towers, we have a Shareholders Association, which is the opposition group.
Oh, okay.
Right, so to clarify, so you were going after really the powers that be.
That's right,
Rivers,
the elected Board of Governors.
Okay.
And of course, one of the interesting things about Twin Rivers is that they have weighted voting for their board. It's not one unit, one vote. It's not one person, one vote. You vote according to the value of your property. So that if your house has an assessed value of $65,000, you get 65,000 votes. If there's an assessed value of $15,000, you get 15,000 votes. And if you own the largest of the 3 apartment houses, you get 3 million votes. So that's one of the things we challenge.
That's the same way we do it at North Shore Towers. Right. Now, do you have an opinion on whether that's fairer, or should it be 1 unit, 1 vote?
I think it should be 1 unit, 1 vote. But of course, that's the issue we've lost on so far. We lost on that issue of the appellate. That was the one issue we lost on in the appellate division.
Anyway, tell us why. Some people feel I have a bigger investment than you. Why shouldn't I get a little more political weight than you?
Well, because they're treating them as like a corporation, and it's a financial interest. But this is not really a business. These are not business. People live here, and people want to have equal right to say in the governance of their community. I mean, we got rid of, property qualifications for voting in this country for public office 200 years ago. So they still think that this is a financial investment and not a residential community. And I think that's the wrong analogy. The other issues were the prohibition of political signs or any kind of signs on people's lawns or other common property.
Right.
The only thing that was allowed was a very small sign in someone's window or in the flower bed where they were not visible from the street. Second issue had to do with some kind of access or right of reply in the community newspaper. Right. There was a monthly newspaper put out by the association called Twin Rivers Today, and it was used as a political soapbox or political trumpet by the president of the board. Mm-hmm. He would use his front page column to denounce his opponents, call them all kinds of nasty names. There might be some right of the opposition getting a letter to the editor back on page 10, right. But even then he would usually append a note rebutting anything they had to say. It was a very unfair, unlevel playing field. Third issue was access to the community room. There was a community room maintained by the dues, the maintenance fees of all the members. Yet if the members one of the members wanted to hold a public meeting there, they had to rent it for $265 plus a $500 security deposit, an insurance rider. And it was the only place around to hold a public meeting unless they wanted to go to a library some 20 miles away, a public library. So we wanted access to the community room on some kind of equitable basis. We were willing to pay whatever the extra cost of opening the room was, to heat it, air condition it, open it up, close it, maybe, $25, $30, whatever with the out-of-pocket cost. We were going to pay $265 for a meeting. Right. Then there were a bunch of subsidiary issues. One of them had to do with the right to tape the board meetings. Members weren't allowed to tape the board meetings when they met. We challenged that, and actually we settled that before the case went very far. Mm-hmm. They rescinded that prohibition. They allowed taping of the board meetings after that. And then there were some other issues that had to do with access to records, alternative dispute resolution. One of our plaintiffs, had objected to a $3 a month assessment for cable TV, which was assessed to every resident, whether they wanted cable TV or not. They didn't want cable TV. They thought they shouldn't have to pay it. Not only that, they thought that there should be some kind of alternative dispute resolution over their objection to paying the fee. And then there was an issue. One of our plaintiffs actually had been at the time a member of the board, and she had been improperly censured because she wanted to disclose material relevant to her constituents that they said was classified and confidential. So we challenged her censure. And those were it. But the overriding issues had to do with what I call the constitutional issues. Signs on the lawn, some kind of equitable access to the newspaper, rental of the community room, and weighted voting. They were the big issues. Among the subsidiary issues was a sort of a statutory problem that Twin Rivers was so old that it predated the state statutes which provided some rights to residents of common interest communities.
By the way, when did Twin Rivers open?
In the mid-'70s. In fact, about the mid-'70s. But in the late '70s, the legislature passed a statute called PREDFA. I don't even remember. If you can remember what PREDFA actually it had to do. But really, what it did was regulating public offerings by developers. And it said, well, if a community is already developed, they're exempt from this, which makes sense because it was already out there. This was to regulate public offerings. The public offerings were over in Twin Rivers, so they weren't covered. In 1993, the legislature adopted some amendments to PREDFA, which gave certain rights to members of common interest communities. Twin Rivers claimed, well, they're still exempt from this. So we'd have two classes of homeowners. Those in communities before PREDFA was adopted, they have no rights, and those after PREDFA was adopted who allegedly had rights. So we argued about that, an issue we finally won. But those were the fundamental issues, and the basic issues were these constitutional issues because our position was places like Twin Rivers they're almost like municipalities. They're quasi-municipalities. We actually call them constitutional actors, which is a phrase the appellate division liked and picked up and agreed to.
Can you elaborate on that expression?
Yeah, that while they are not quite public facilities, they are subject to the fundamental rights given to citizens under the New Jersey Constitution. That shopping malls are constitutional actors. They're not municipalities, we recognize that. Right. And these aren't quite municipalities, but they perform public functions that many municipalities perform. Therefore, the appellate division agreed with us, they are constitutional actors. And they have to abide by the constraints of the New Jersey Constitution, which do provide certain basic rights to citizens, to people who are on their property.
Professor,
yeah.
When recently a book was published called Speaking Freely by another attorney, Floyd Abrams, who
right. specializes
in this area of the law.
Right.
And when he was interviewed on The Daily Show by Jon Stewart, he asked the author, of all of the amendments to the United States Constitution, which I believe there are 27, he says, how would you rank the one pertaining to free speech? And the author Abrams said, well, first. And I would assume that you would concur.
Well, I certainly concur also. I think the 13th and 14th Amendments are pretty important also.
And what are they about?
Well, the 13th Amendment abolished slavery.
Okay.
And the 14th Amendment provides for equal protection of the laws.
Right.
So they're all very important.
But tell me why you've devoted your whole life to upholding the Constitution. What is it that's so important about free speech? Why are you taking so much pains to see that the Constitution is lived up to? Why is that important?
That's an interesting question. And maybe I got to go back in my own personal history. When I was a teenager growing up in Baltimore, I was a community activist. I was part of an early civil rights movement in a Jim Crow city. This was before Brown versus Board of Education. And we were a small group that tried to influence public policy. We didn't have any money. We didn't have money for mailings or billboards or radio. How do we get around? We had to find out where people were. And in those days, we had a mimeograph machine. Nobody remembers what a mimeograph machine is, or you got to be over 70 to know what a mimeograph machine was. Where we cranked out our leaflets. And we had to go to places where people congregated. It was usually public, street corners in those days, or maybe a ball game or a railroad station. But at least in those days, there were public streets where people did congregate. There were downtown business districts. Those public forums have all been privatized, mostly now. I mean, now, as Chief Justice Willen said in our shopping mall case in New Jersey, Main Street has moved to the shopping malls. And he said, if Main Street's moved to the shopping malls, people's First Amendment rights have to move there with them. And now, we have private people. You used to be able to go door to door and slip a flyer under a person's door. They're public streets. Well, those public streets have now been privatized. So again, in Twin Rivers case, we said, well, when the public streets become privatized into these common interest communities, the right of free speech and communication has to travel with them. And the appellate division, again, agreed with us. Anyway, when I was a kid, this was very important to me. It's called what I call grassroots organizing. It's organized, or as Justice Hugo Black of the United States Supreme Court once said, he said the First Amendment has special solicitude for the poorly financed causes of little people. And when I went to law school and read that line, I said, well, he's talking about me. That's what I was involved in, the poorly financed causes of little people. And so I got very interested in this whole notion of how you communicate, how people in a democratic society get to talk to their neighbors and associate with their neighbors. And it just seemed to me, in 1968, I was already out of law school. I applauded when the United States Supreme Court, in an opinion by Thurgood Marshall, ruled that these private shopping malls were public forums under the First Amendment. Unfortunately, the Nixon court, 4 years later, overruled that. They said, no, private property, private property, private property. So that was the point where these issues of freedom of speech and these so-called private communities had to move to the state courts. under state constitutions because we have no rights under the federal Constitution. And under this, a current Supreme Court, it's still that way. The majority of the Supreme Court believes in property rights over individual rights. In New Jersey, it's the opposite.
Right.
In New Jersey, long ago, the New Jersey Supreme Court said, when property rights come into conflict with human rights must prevail. And that's been the New Jersey law.
Right.
And that's why I feel I'm fortunate being able to litigate these kinds of issues in New Jersey. And hopefully, occasionally, some other states will follow New Jersey's lead. But we have very good law on free speech in New Jersey.
All right, let's get back to Twin Rivers, if we can.
Okay.
What's been going on since 2004? You had a bit of a setback then?
Well, we lost in the trial court. It took the trial court 3.5 years to finally issue a decision, unfortunately.
Right. Did you expect to lose at that level? Sometimes lawyers say, well, we know we're going to lose at the lower level. It won't be till we get to the appellate.
Yeah, who knows? I hope for the best.
Right.
Didn't know but I knew it was always going to go up. It didn't mean a whole lot whether we lost there or,
Right.
In fact, to tell you the truth, sometimes you're better off losing in the trial court because you get the right to appeal.
Sure.
First time I tried a shopping mall case, I won in the trial court and the other side wouldn't appeal. And it was useless. It was a useless win. So sometimes you get lucky to lose in the trial court.
Right.
You then control the appellate process.
Okay, so what was the ruling in 2004? It went against you.
Yeah, the
I think
judge,
it was Justice
Schuster. He had two basic points. One, he disagreed with us that these were public forums. He said, well, this is different than shopping malls because they don't invite outsiders to go into their property. But we weren't even talking about outsiders. Our clients were invited to live on that property.
Right.
So why they didn't have rights while outsiders did at shopping malls was never clear to me. And then he said, but it didn't matter because they were still bound by contract. They had bought these properties knowing that these deeds were in there, all these restrictions were in their deeds and contracts of sale, and therefore they waived their rights. And I'm going to make an aside now. I'm at the moment in the process of my wife and I of buying another home in a common interest community. We're in the contract stage, and I said, "Well, where are the bylaws and the CCRs? I want to read them." They said, "Well, you can't get them. You'll get them at the closing." I said, "Wait a minute. I'm going to sit at the closing for 3 hours, paying my lawyer, who knows how much money an hour to read the CCRs and bylaws? Is that what you think people do?" So, it's nonsense. Nobody knows what's in they're buying a pig in a poke.
Right.
They don't know what they're getting.
Sure.
And of course, the appellate division agreed with us on that point, that you couldn't, these cases are not to be decided on the basis of contracts with these kinds of take it or leave it, no bargain contracts. They aren't real contracts. As I said in court, I said, if you he said to the seller, well, I'll give you an extra $500 if I could put a sign on my lawn. They laugh at you. You don't have a right to put a sign. There's no way to put a sign on your lawn. There's nothing to bargain over. It's take it or leave it. Yeah. So that's all sort of that's a fiction. The notion that you've waived your rights. You knew what you bought. You accepted all these rules. So anyway, but those were the two issues by the trial court. Based it on they're not constitutional actors, and if they are, you've waived your rights. And those are the two big issues, and we won on both of those issues in the appellate division.
Okay.
And that's where we are.
And now I understand that the Homeowners Association, which again represents Twin Rivers Management, is now appealing from that decision to the New Jersey Supreme Court?
Well, that's right. They have filed a petition for certification, which is discretionary with the New Jersey Supreme Court. They'll have a couple months to decide whether to hear the case or not. Now, it does raise important constitutional issues. And as I told the court in my reply, I said I certainly can't deny that it raises substantial constitutional issues, except I think the appellate division opinion was so solid and based on your former precedents, you could just summarily affirm what the appellate division did.
Okay, now for my viewers, we're going to be watching this in Queens. The big question is, all of this is occurring across the Hudson River in New Jersey, and everybody wants to know what, if any, precedent value will it have? Is New York obligated to? No. So
absolutely not.
So
hopefully it's persuasive. All you can say is it's persuasive.
All right. Well, now supposing you lost with the New Jersey Supreme Court, is there a chance of appealing this to the Supreme Court of the United States?
No, not really.
And why is that?
Because there's no federal issue involved here. These are all issues under the New Jersey Constitution, and New Jersey Supreme Court is the interpreter of its own Constitution. And the United States Supreme Court, even in the shopping mall cases, has said the federal Constitution is a floor, it's not a ceiling. And if a state wants to provide more rights of free speech than the federal Constitution does, they are free to do so. Now, in the shopping mall cases, the shopping malls tried to say, well, they tried to create a federal issue by saying it was a taking of private property without compensation, which is protected by the federal Constitution. They said by allowing somebody to come and gather petitions on their property for a little while, that was a taking of their property and they should be compensated for it. The U.S. Supreme Court rejected that notion out of hand. So I just don't think there's any takings issue that's. I mean, I guess the associations could claim again it's a taking, but I don't. Even with this conservative Supreme Court, I don't think that's going to get anywhere.
Right. Now, how does this relate to what's been going on over at Galaxy in Guttenberg? Well, I understand that the action was sort of backburnered until the Twin Rivers decision was reached.
Yeah. Well, this is now Galaxy 2. We did bring a new Galaxy case a year or so ago. The most unique piece of the Galaxy case has to do with their in-house television station. They have an in-house television station broadcasts their monthly board meetings live, where they do not allow any opposition voice. There is no public participation in those board meetings. If somebody tries to say something from the floor, the TV is shut down. And then they rebroadcast that board meeting every day until the next board meeting. And often the board members will criticize their opponents. They use it as a sounding board for their own, advance their own ideas. And the opposition says, well, we ought to have some access to Channel 26 as well. And that's really the unique issue about Galaxy. But right now, Galaxy is stayed. We finished discovery. But Galaxy is stayed pending final outcome, basically, of the Twin Rivers case.
All right, but there's no in-house channel at Twin Rivers.
No,
is that correct?
That's correct. The closest thing between Twin Rivers and Galaxy is the newspaper.
Right. And you feel that it's just different media and basically the same principles?
I think the same principles should cover, who knows? I mean, I advocate the courts decide.
Good answer.